This special meeting of the Belleville Zoning Board of Adjustment for April 17, 2019 will now come to order. Clerk, call a roll.
Bennett. Here. Caruso.
Here.
Giordano.
Here.
Lopez.
Here.
Lozoff. Here. Catalino. Sheldon.
Here.
Milano.
Here.
Del Garcia.
Here. Will everyone please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Madam Secretary, has notice of this meeting been given in accordance with the Sunshine Law?
Certification of this meeting has been advertised according to the Sunshine Law.
Okay. There's no minutes to approve tonight, and there's no application for adjournment unless Mr. Gassion wants to do that.
No, I do not, Mr. Chairman.
Okay, and there's no resolutions to be memorialized, and no communication. So we'll get right down to the meeting, to the case that we're here for, ZB 2019-02, 125 Academy Street, St. Mary's, St. Mercurius Church. The applicant is seeking approval to construct a new parking garage and a new church facility to be known as a youth center and to renovate the existing parking area. Mr. Gassion, by the way, the notices.
I've reviewed them. I think Gina has reviewed the notices as well, and I find them in order and appropriate.
May I address the issue of the notice?
Yes, sir.
Thank you.
I would love for you to do that.
You would.
Yes.
I'm sure you would. First of all, it's a pleasure to be back in front of you. It's been a few years. Spent a lot of time together last time. Some new faces, some not.
And we certainly never forgot you.
The feeling I will say is mutual. So before we begin on the question of the notice, as you may recall, when we were here last time over those many, many days, one of the issues that was raised on appeal was the lack of adequacy of the notice.
And that was the basis for everything being overturned.
Well, respectfully, I don't think that's true. I was there. There was an ultimate withdrawal of the application. There was a withdrawal of the...
Mr. Fiorenzo, if I can stop you for a minute.
What's that?
Let's put your name on the record,
Yeah.
and I'd like you to tell me specifically who you're representing.
Certainly.
Although,
You're right, I
during
apologize.
the course of the hearing, no, it's my fault.
I've been in a deposition all day and my mind is a little fried. So.
Okay.
I represent Rutgers Court, Associates LLC. I'm an objector to the application. Joseph B. Fiorenzo, Seals, Cummis, and Gross, Newark, New Jersey, One Riverfront Plaza.
Okay. And who is Rutgers Court LLC? Again?
It's a limited liability company, the principal owner of which is Mr. Jerome Lombardo. No change from the time I was here last time.
If I might, obviously, council took over before I had anything to say. I'd like to deal with today's case, not the last case. We have a case in front of us that has nothing to do with the last case.
Put your name on the record, please, just so we can get that straightened out. Could you state your name, put it on the record?
Council's name is Robert Gassion. I represent the applicant. The firm is Gassion Pomaco, 524 Union Avenue in Belleville.
Okay, thank you.
May I complete my discussion on the notice issue?
You're talking about the current notice.
Yes, the current notice.
Okay.
Absolutely. Yeah. So, and I gave that by way of background because, as you know, the lack of proper notice is a jurisdictional deficiency. We believe that the notice as currently presented does not provide adequate notice to the public. I would cite, just for the record, the case of Pearlmark of Lacey, Inc., 295 New Jersey Super, 237-38, which talks about the need and the purpose of notifying the public as to the nature of the matters to be considered, and also to ensure that the people affected are fairly apprised of what the application is about. The notice that has been presented here is broad, conclusory, abstract, gives none of the details of the size, scope, and the nature of this project. The 52-foot height, it gives none of the particulars. This is the type of notice that our courts have expressly found in reported cases. And again, we briefed all this the last time around, which led to the withdrawal. So I'm raising it right up front. We believe the notice to be inadequate. It doesn't reasonably apprise the public of what this significant, large application involving front yard variance, a 10% deviation, side yard variance, a 33% deviation from the code, lot coverage variance, 23% deviation from the code, height variance, 49%, impervious coverage, 60%, open space, it goes on and on. So I wanted to state for the record that this notice is not adequate under the cases which candidly the applicant should be on notice of, because these are the same cases we cited in the appellate briefs, which ultimately led them to withdrawal of the last application. Here we are now about to commence this hearing, and we're in the same situation, despite the fact that they have notice. So I respectfully submit and would state for the record that this matter should not proceed tonight, because the notice does not reasonably and adequately provide notice to the public of the nature and scope of this application. And should we proceed without a new notice, this application will be infirmed. We'll find ourselves back here again, just like we did last time. So that's number one. Number two, I also want to place on the record that in my view, in my review of this application, that this is little more than a rehash of the last application that was before this board. And under applicable law, to the extent that there has been, we fully litigated last time the application, we went up to the Superior Court, we went up to the Appellate Division. In my view, legally, since this is substantially the same application, seeking substantially the same variances as last time, with regard to a project substantially identical in scope, that they do not have a right to come back now and relitigate the questions of the past. They chose to withdraw the application for approval last time. So in my view, based on applicable law, they should be barred from proceeding forward with the substantially identical application that we litigated last time, and they ultimately agreed to vacate the approval. So I want to note for the record that I believe under any circumstances, putting aside the question of adequacy of the notice, that the underlying issues presented in this application, because they're substantially identical, this board should not hear them, because under principles of res judicata, this matter should be deemed resolved. If there's a new application they want to make, other than the one that's substantially identical, with virtually the same variances sought, they can make that. But this is substantially identical to the prior application, and therefore they should be barred. So I wanted to place that on the record before we began, to give this board an opportunity to consider those issues before we proceed, because to proceed, in my judgment, would be ill-advised and place us in the same position we were last time around, where we'll spend an awful lot of time, awful lot of effort for naught, having to come back here and do it again. So I just wanted to note that for the record.
Your
Yes,
response.
Yes.
Well, first thing is, counsel did not give me the courtesy of letting me know what his arguments were. I gave him the courtesy of calling him or providing him with a copy of the plans. He said he hadn't had them. So I did not have the courtesy of that notice. Therefore, I'd like to have a 10-minute recess to talk to my clients prior to responding.
There will be a
No
10-minute
objection.
recess. We'll come back 20 after 7. Okay. The special meeting of the Belleville Zoning Board of Adjustment for April 17th, 2019 is now back in session. Mr. Gassion, your response.
Mr. Chairman, thank you for allowing me the time to discuss it with my client. Obviously, I did not handle the case on behalf of the applicant the last time. Counsel did represent the objective. I am not as familiar with that application as he is, and therefore, I foresee the strong possibility of an appeal on this case, and I do not want to go on the record with my response to res judicata issue without the plans available to me. So I'm going to request an adjournment to respond to both his arguments. One as to inadequate notice, which I probably could respond to now, but I'm not going to because I'm asking for the adjournment because of the res judicata issue. My apologies, but as I indicated, counsel did not advise me of what his argument would be in advance. Therefore, I am not prepared with the plans from the previous application.
So when...
Wait.
I would like...
Wait. Go ahead.
I understand your request. I've gone on record already as stating that, in my opinion, and totally up to you, Mr. Gassion, what you want to do, in my opinion, this notice is proper. Mr. Fiorenzo cited the Perlmar case, which I'm very familiar with. You'll notice, Mr. Fiorenzo, if you have that case in front of you, there's a footnote at the bottom of page 397. It's footnote 3 that talks about the appellate division specifically said that it is not necessary for an applicant or for a notice to go into the level of detail that you suggest. And I want to argue with you that issue was strictly because someone wanted to build a food market or a ShopRite and never said in the notice we want to build a ShopRite. The appellate division indicated that the legislature never intended any applicant, although many do, never intended an applicant to put feet, inches, what the deficiency is. I'm looking at the notice. It lists the deficiencies. It does not list the details of them. Also, Perlmar talks about a notice not written for someone who knows land use. It's written for a common person, a layman, someone who's sitting at a coffee table and read the notice and say, okay, tonight, because this notice does have where and when the hearings to take place, it indicates where someone could go to get the plans, it indicates the street address and lot and blocks of the property, and it indicates, in my opinion, generally what we're here for. We're here for a new church facility, new parking garage, renovate the existing parking area, and those are the 4 criteria that are set forth in the municipal land use law for notice. As far as res judicata, I have no idea what res judicata, what that issue is doing in this case. This is a new application, years later. I wasn't here first time around, but I understand this is different. Res judicata comes into play when there's an application denied, and the applicant comes back a month, 2 months, a year later with the same application, and the board has and it's not mandatory, the board has the option of hearing again or not hearing again. Res judicata, to me, does not enter into this at all. Those are my 2 cents. Mr. Gassion, if you want to adjourn it, that's fine, but that's...
Well,
my views are not going to change.
May I just respond briefly?
I appreciate you putting those on the record. You have to, I know, but I think neither of them carry much water.
Well, okay, respectfully,
Yes.
I disagree. I was here,
Okay.
I've lived through that application. If you compare the prior notice that was sent to the current notice, the prior notice provided much greater detail than the previous notice, which led the appellate division to tell your counsel that there was a serious problem which led to withdrawal of the application. And let me just say this, if you review this...
What was the problem with the first notice?
The problem with the first notice is it didn't reasonably describe with sufficient detail so that as a layperson, as you just mentioned, would reasonably be aware of what it was that was proposing to be developed, what the scope of the project was, rather than, like here, saying, quote, requesting preliminary final major site plan approval, use variance approval for maximum permitted building height. What does that mean? You've got to give more detail so the public, the layperson reading it, will know about the size, scope, and extent. It goes on in this notice to say that it's for a house of worship. Well, that's not true. This application isn't for a house of worship. There's an existing structure on the site. This application is for something fundamentally different. I had a chance to look at the architectural plans. This is for a youth center. This isn't a house of worship at all. So if I'm a layperson reasonably looking at this, and it tells me it's a house of worship and not what it really is, that's exactly what the appellate division said, and the courts have said you cannot do. And that would make this entire proceeding a nullity. If you want to go ahead with it...
No. Here's my problem.
If I may just respond to that.
I put it on
My
the
problem
record.
is Cyril and Mr. Gassion.
You proceed at your own risk.
I was not here the first time around, nor was Mr. Gassion.
It doesn't say house of worship. He's misquoting.
Okay.
It says house of worship use. It doesn't say house of worship.
Why don't we do this?
There's a difference.
Mr. Gassion, if you're going to request an adjournment, what I would suggest you do, just to be on the safe side, redo the notice. I don't know if you have to, but if I were you, given what's been raised, I would probably redo the notice and be a little more specific as to the fact that there's going to be the classrooms, cafeteria, something like that.
Gymnasium, basketball
To take that
court,
issue away. And if you want to prep the issue of res judicata, that's fine. Again, this is a brand new application. I don't know where res judicata comes in.
Well, I'm happy, so if we're going to adjourn tonight, and that's up to the board, But if it's going to be adjourned, I'm happy to submit to you some legal authority for that, because I've litigated this question. I've got a matter before the appellate court right now concerning its precise issue, and I believe that if one looks at the original application...
We're not talking about collateral estoppel here, are we? Or anything like that?
No.
Because we're in the wrong
No.
pew for that.
No. I mean, I'll give you the cases on this. It's
We
pretty-
certainly can find the cases without you giving to us.
Well, no, give them,
Then I will.
You know what I want
No
to
problem.
ask, and here's why I'm intersecting. Do you have a copy, when you went to Superior Court,
Yeah.
of any decision that was made?
I have a copy of the letter from your attorney. Once we took the matter up on appeal and we met with Judge, forget the name of the judge, your attorney no doubt reported to you what happened at that conference, and the judge urged that they reconsider because the likelihood was that they would not prevail. As a result of that, your counsel then wrote a letter saying that they accept the argument that the notice was defective, that there was no jurisdiction.
You're talking about the board now.
The board, your
Okay.
counsel. And if you remember, I don't know if you recall, but when they did that, we actually objected to that. We said, no, we don't want to be in a position where they now have a chance to say, okay, we agree, the approval was a nullity. We wanted the appellate court to rule on the substance of it because we believed that the entirety of the underlying decision was flawed and wanted that ruling. The appellate court said, we are going to accept your withdrawal of the approval, which thereby vacates the appellate court further jurisdiction to hear the matter. I have that.
That's what we did.
I have that
remember doing it.
communication, Mr. Chairman, if you'd like that.
Yes, I think you should send that
I'll provide that
to
to your
Mr.
counsel.
Gassion and to Mr. Rego.
I'm happy to do that.
all right, why don't you, again, I don't see
But,
where
but
it
wait,
fits in.
one thing to interject. Wait. I remember we did exactly what you said,
Yes, sir.
but I never remember the applicant withdrawing the application.
No.
That never happened,
uh,
that I know of.
I'll show you.
That's what he's saying.
What I'm saying is that the counsel, your counsel for this board,
Right.
indicated, and this was without objection to the applicant. The applicant had to agree because the applicant was a party. The applicant also agreed, after conferring with the town attorney, that the approval that was given,
You mean the board attorney?
the board attorney and the attorney for the applicant both agreed, after we met with the appellate court and the judge told us what she did, that they would withdraw the resolution of approval and it would be deemed to be a nullity. That's what happened. We didn't want that to happen
Without a ruling?
without a ruling.
So no
Without
court
a
ever
ruling.
ruled that the notice was defective?
Right. So what happened was, there was a conference, there was a settlement conference with the appellate division judge who said, you're going to lose. And as a result of that, your counsel said, conferred with the applicant, they agreed to withdraw the resolution of approval. We objected to that because we wanted to have a substantive, it had been fully briefed, we were ready to go to argument. We wanted to have a substantive ruling that the actual approval that was given, putting aside the notice, was defective and never should have been granted. The appellate division ruled over our objection that they had a right to agree to withdraw the resolution of approval. That's what this board then did. As a result of that, it mooted the appeal. The appeal became moot. And so now here we are, I don't know, 2, 3 years, however many years
Long
later.
time.
4 years later, I don't even know.
6.5 years at least.
I got an email saying, we're back.
Mr. Gassion, did you know about this? I mean,
No.
I had heard that the court ruled notice was, so that was just, it was just an agreement made to, once it got to the court process, Mr. Campbell withdrew the approval.
Mr. Campbell,
Mr.
in
Campbell.
conjunction with the attorney for the applicant, both petitioned the court and said, we are going to withdraw the resolution of approval, therefore, appellate division, please dismiss the appeal. We then objected, went back and forth, and the appellate division ruled, well, you know what, since they withdrew the resolution of approval, it's a moot point, there's nothing before us anymore. And so here we are today. And
And we're starting new.
well,
We're starting new today.
Mr. Rego, we are, but I would argue to you that if you review these plans and you compare them to the, we're not starting new at all. This is basically the
What
same.
difference does it make? The board previously approved it. It was agreed that the approval was withdrawn, so the church has nothing. right now.
Yes.
They're coming back in, I think, six or 7 years later.
6.5.
Okay, and they're coming in with something, again, which, from what I'm told, there's a difference between one thing and the other, between the plans, and they're taking another track at getting approval. But we have at least 4 new board members, and this is my first time here with this.
Right.
We have a different planner, Mr. Gassion's different. Why? You can write what you want, but I just don't see this as other than a garden, not a garden variety, but just a new application for this facility, and we want to get, and I understand it went 10 months last time, which I think for a case like this, for 10 months, is, I don't know how it happened to be that long. I understand it was equivalent to a professional wrestling match at times.
Yes.
Which I'm hoping doesn't occur anymore.
Mr. Chairman remembers
Mr.
that.
Gassion
Very well.
is too old for that.
He's a gentleman, and I can assure you, we will not.
He's a gen-
He's a gentleman, and we will be
He's calm.
professional.
Okay, but okay.
If I get surprised again, I won't be.
Okay, just, if maybe you could, feel free to pick up the phone and fill Mr. Gassion in on what happened, because I thought there was a court ruling saying the notice was bad.
No, that's
Mr.
incorrect.
Valano.
That's incorrect.
I would ask that you would get the same data
Yeah, okay.
that they're getting.
Yeah,
So
well,
move
that
it
he
down.
has.
What I would suggest is if you want to proceed with an adjournment, that's fine, pick a date. I would suggest, although there are a number of people on the list, I would suggest that notice be above and beyond what you normally would.
I thought the notice was adequate. I'll take your comments into consideration.
Okay.
My main concern is being prepared to argue the re judicata argument.
Please
When
get me
would-
a copy of whatever you have on
Yes,
that.
yes, get a copy to both of them,
I
so
know.
that way I
Well-
can clear this up. The thing is, when would you like to adjourn? I want to point out ahead of time that Mr. Giordano will not be at the regular May meeting of May 3rd. Do you want to do this for June? That way you have plenty of time to straighten this mess up.
Well-
Whatever you want to do.
Or we can carry it to,
May 2nd, I'm sorry.
we can carry it to a regular meeting, knowing it's not going to be heard, but that way we can preserve notice. We can carry it to a
That's what
regular
I would
meeting
prefer to do.
between now and
Just
the
carry it
regular
to the
meeting.
next regularly scheduled meeting.
Of
And
May
at that
2nd.
We'll pick
we'll
dates.
check where we are, and maybe we can pick a date, if I can impose upon the board for another special meeting date, I
Well,
would
the
like to be
special
able to do
meeting
that.
dates, I already checked for you for May. They are, I believe, and Gina's here, I believe it's the 7th, the 15th,
And the 21st.
and the 21st, exactly.
I'd rather take the longest date out, but I need to check with a couple of potential witnesses before I select a date. That's why I prefer just to adjourn it. I will not be proceeding, obviously. I'm not going to surprise council and try to proceed
But what I'm
at the
saying,
next
do you want to
regular
adjourn to
scheduled
May
meeting.
2nd?
Yes, I would like to adjourn it to the regular meeting date, and then hopefully I'll be seeking a special hearing date at that time.
Now,
Between now and then, hopefully I can get the documentation from council or from John Campbell, so that I know exactly what happened.
We're going to need to know prior to the May 2nd meeting potential dates, so we're,
Yeah, the problem with all this is, one date that would be eliminated, automatically eliminated, would be the May 7th date, because you gotta remember, when we have to still advertise for a special meeting, and we have to give 10 days notice.
I think May 21st is the most likely special meeting date if we request one.
Okay, I have no problem with that.
while we're here, could you
Does
just,
anybody in the board have a problem with May 21st in case we want to have a special meeting?
Don't know now. Here I don't know. I haven't checked.
I can't wait to see you all again.
Well, fortunately, there's
I couldn't give any other positive answer.
yeah,
a number of board members, and we...
Mr. Padalino is the only one that's not here. But while we're here, if we could get a sense of the witnesses that you, not, we don't know the names, but just the witnesses that you'd intend to call in your presentation.
Well, I'm going to call a representative from the church, one of the
Right.
priests. I'm going to call a site engineer. I'm going to call the architect. I certainly am going to call a planner.
Okay.
Other than that, I am not sure who else I will be calling. Those are the 4 that I for sure will call.
Minimum.
Fiorenza, what do we?
Minimum.
You know, I just got into this in the last couple of days, so I'm scrambling here to play catch-up. I haven't determined that as of yet. I would expect, there's a good chance, much like last time, we called a planner. I would expect we'll do the same here. There may be some fact witnesses concerning the site and concerns and conditions. But I'll be in a better position to let you know the next time we meet after I...
Who was the planner first time around? I guess?
For us, I believe we had Mr. Burgess, Joe Burgess.
Joe Burgess, okay,
Joe Burgess.
okay.
Yes,
Okay, and the applicant had
Mr. Steck.
Peter Steck, okay.
Who I think may be coming back in again, I think.
That is correct.
Okay.
What is that?
Yeah.
Oh, he's coming back?
Yes, he is.
Oh, I like that. This is good. All right, so we'll carry this to May 2nd. Now, let me ask you something. Technically, the May 2nd argument is only going to be on the issues that was brought up tonight for the
Yes.
notice and all.
Yeah.
It's not going to start the case, so it would
Correct.
not disqualify Mr. Giordano. Am I correct?
And they may not even be made at that point if I haven't had the opportunity to see the documentation.
They don't even have to be here for May. May 2nd strictly for us to give
Set a
them
date. I don't,
a date.
Right.
They don't, there's nothing gonna happen.
So we don't have to show up on the 2nd?
I will show up because I'll be looking for a date.
Oh, okay.
So,
Just make sure you're coordinated. We don't wanna get all set and you're okay and then Mr. Fiorenzo says.
Yeah, I'll come down as well.
if he
It's always
doesn't want
nice
to come,
see
if
you
he can
guys.
give
I'll
me his
stop
dates,
in.
that's
You should
fine.
be here.
Whatever he wants
I'll
to
be
do.
here, I'll be here. Just see what we're doing. And so on the 2nd then, we'll come in, we'll do a date, fix a date for the next meeting.
For a special meeting.
And there'll be no testimony, but are we going to deal with any of the two substantive issues that I just raised tonight, or how do you want to handle that?
That's my question.
Well, do you think between now and then you'll be able to gather your thoughts and put it in writing or?
I don't plan necessarily on putting anything in writing,
Okay.
but if I were to be reserving, I need additional time. It won't work, a reservice won't work at this point, not for May 2nd. And I haven't decided whether I'm going to reserve it, it won't work.
Well, if we carry
Well-
it to May 2nd, you won't need to renotice anything right now.
For
Right.
May 2nd.
It's for the
It's
next.
for
If
when
I'm
the
going to-
special meeting
right.
would take place.
So
When we
again,
notice.
if we could do May 25th as a tentative special meeting,
May
that,
24th.
24th, whatever it is.
21st, I'm sorry, 21st.
21st. That would give me the necessary time.
Yeah, May 21st, yeah.
It's up to you as to whether, if you want to have some sort of oral argument on the 2nd as to these two issues, or we can, you take a little bit more time, because May 2nd's going to be here quick.
If I could get the documentation quickly, I'd rather get it resolved on May 2nd, so that come May 21st, if everything's okay, we're going to proceed.
Can you
the
let,
case.
maybe you can let, we should be prepared either way, just to give it.
But if I don't get the documentation from John Campbell or opposing counsel, it's going to be difficult. I don't think my clients will have what's necessary.
Molly, go ahead.
My thought is,
Yeah.
if at all possible, we should allow them to make the arguments. If you get all the documentation, from previous counsel, from yourself, I would like to hear the argument if we could, try to move things along a little bit. So if we can do that, that would be great. I would just ask, if neither one can do that, we get notified that you can't do that because documents will not come forthcoming.
I think,
I don't think that's unreasonable.
I don't think it's unreasonable either, and I'm gonna come right out and say how I feel. I would like to get this issue resolved before we do anything else with the case, because I do not feel like hearing this case a third time. And I think all the other board members who heard it the last time will agree with me.
No, I'm fine.
Well, and Mr. Chairman, obviously, that's why I want to take the adjournment to clarify it, because I don't want to leave an open issue for appeal on the record.
Yes,
That's fine.
fine with me,
Take a look at Perlmore,
fine with you.
I'm familiar with
do
it.
what you need.
I have no problem with the
Mr.
notice
Chairman.
issue.
I'm happy to
I love when
accommodate
everybody
my new
agrees
friend,
with
Mr. Getchio, tonight. Happy to do that.
I won't push that out, no.
So,
There'll be no need to call in the police this time, I'm sure.
I'm not
Let me tell you something. That has gone down as history as the only time I have ever had to have a cop stationed because of the attorneys.
If I ever wrote a book about my life as a lawyer, there'd be a chapter devoted to that.
Yes.
Just that.
If I ever write a book about being chairman, that would be. So wait, we're agreeing to go to the second, correct?
Agreed to go to the second, we will try to make the argument on the notice issue and the re judicata issue that night.
Okay, all right. So everybody in the audience heard, we're not gonna start the case that night. That's to just get through the question about the notice, period. And if we're gonna have another special meeting. Okay? Everybody happy? Everybody understands? Okay, motion to adjourn by Mr. Valano, seconded by Mr. Giordano. All in favor?